Good afternoon, everyone. Thank you all very much for coming. What a great turnout. My name is Artur Oliveira. I am one of the Chicago leads for talks at Google. I also work in people dev on my daytime job. I am very happy today to introduce to you Jerry Buting. He is a defense attorney from Brookfield, Wisconsin. I think a lot of you have heard of him on Netflix's Making a Murderer. Him and his partner in that case, Dean Strang, are going on national tour to talk about justice, a conversation on justice and the criminal justice system. So with that, if we could please help me welcome up Jerry up to the stage.
Hello. I'm here?
Yeah.
Okay.
Welcome to Google.
Thank you. Thank you
for being here.
Thanks for everybody for coming out.
Yeah.
Beautiful afternoon.
It is a beautiful day. Summer should be here. Is here, I guess you could
say.
Yeah. Well, Jerry, like I said, thank you for being here. We know that you're on tour. You and Dean are going on tour. You've been on tour for a couple of weeks. You have a few more stops along the way. What brought about that tour?
You know, it really sort of arose out of what we saw happening after the documentary came out. As the media would ask us about it, they would interview us. It was the same sort of process that we saw before the trial, where when we were interviewed, or let's say during those press conferences that you saw at the end of each day in the documentary, we'd go through 20 minutes, some 30 minutes of interview, and then 2 minutes would end up on the TV, and what they would pick would be sometimes silly, sometimes not, but in any event, 2 minutes wasn't enough to deal with the really serious issues that this documentary brings to the forefront. And so we just talked about it and said, wouldn't it be good if we could have like a forum where we could actually, unfiltered from the media, people could come, write their questions down, have a moderator ask them what's on people's minds, not just an individual reporter, and really have more of a conversation about the issues that are not just in this case, but in lots of cases. And so that's what happened, and we, a promoter suggested we could do a couple shows, and then those worked successfully, and then it kind of grew into the national tour.
Sure, that's really interesting. So you're in Chicago tonight, and thank you for stopping by Google. And as I was thinking about the opportunity to talk with you, specifically on the criminal justice system, something that came to mind right away was something that you said actually in the documentary, when you mentioned that we can always say we're never going to commit a crime, but we can never guarantee that we'll never be accused of a crime. In that situation, good luck in this criminal justice system. And that to me was a very powerful statement, and so I wanted to bring that up to you again and just ask, what are the implications of that to us as private citizens? What is the implication of that to our society?
Well, it's really, I can't say that it's an original thought. It's a bedrock of our criminal justice system. It's why we have a presumption of innocence. It's why we have the state with the burden of proof and not the defendant, because again, you just don't know if somebody's going to falsely accuse you. It's tough, and you hope that people will give you the benefit of the doubt and apply the presumption of innocence. The reason I said good luck is because that's shifting a little bit in the last 20, 30 years maybe, where I think it's harder for people to do that. There's much more of a punitive attitude. Now, in the very recent year or two, it's starting to change, but it's been more difficult to get people to put aside their preconceptions about, particularly in a high-profile case, and really apply the presumption of innocence. And what happens is, a judge sits up there, and they read and then later give a packet to a jury when they go off to deliberate, a written list of jury instructions. And these, the definitions of, well, what does it mean to be presumed innocent? And what is it, the state's burden of proof? And it's very dry, and it's hard for people to apply it in their own lives because it's different than what you would do normally. If somebody, I say this with parents, if you have a child and one kid comes to you and says, he started it, and the other one says, no, she started it, and you want to hear both sides, and you want to try and weigh one against the other. That's sort of intuitively what we do with in our daily lives, but that's not what you're supposed to do in a court. Because you have to presume the person who's been accused innocent, and then you have to make the state disprove that, prove to you that they're guilty. And it's something that's a little bit counterintuitive, and it's hard if a judge is just reading off some dry jury instruction for people to really get that.
Yeah. When it comes to the presumption of innocence and putting the burden of proof on the state, how has the evolution of technology and real-time communication that just gets faster and faster and more every year, how does that impact a defense case?
It's a real challenge, and it's probably a bigger challenge when the trial's going on in terms of, jurors they're supposed to base their decisions only on the evidence in court and not what someone tells them outside of court, what they read in the newspaper or more likely online. And it's difficult to, first of all, juries by and large are not sequestered like in the old days, where if it was a serious homicide case, the jury was sequestered. They'd stay in a hotel throughout the trial, and most of the time it doesn't happen anymore. They go home, they're told, don't watch TV, don't look things up. And in this case, as a matter of fact, in the Avery case, I was going back through a transcript, and I saw that there were things at the end of the 6-week trial, stuff was coming up that some of the jurors may not have been following those instructions. And the judge went through a whole question and answer one-on-one of each juror. And we kind of suspected which ones were maybe the offenders, but he brought them all out so that nobody would be singled out. And one of them admitted that her husband had very strong opinions, and he'd watch the TV and see what would happen, and he would tell us what went on once we left the courtroom. And the juror denied that, but admitted it to another juror. And so it was kind of one juror's word against the other. Another incident that came up was that they were talking about how they weren't supposed, the judge said, because by then, even 8-10 years ago, judges were instructing jurors, don't go online, don't look stuff up, stay off the computer. And now cell phones, smartphones, it's as technology evolves, it's becoming harder and harder. Right. But one of the jurors was asking questions about, well, if it's, nobody would ever know if you delete it off your hard drive. And another one was saying, oh, no, you can't do that. It's there. They can still find it. And this juror who was saying, they would never find it, all of a sudden became white as a ghost. As if they had been doing that, and I could get caught. So it is a challenge. And short of really, really getting people to promise and understand why it's important that they focus only on the evidence in the courtroom, not something, particularly nowadays. You go online, you hear everybody's got a point of view. So much of it is just speculation, and it really wouldn't be fair to anybody to go through a process like that and have your guilt or innocence decided online rather than in a courtroom. Right.
Yeah. No doubt. I think if any of us found ourselves in that situation, that's what we would hope for. But people can't help but comment sometimes and make that decision.
Gossip is a tough thing to avoid.
Now, at the end of any case involving a jury has to make a decision, right? And when it comes to the impact to society, what would be more preferable? Would it be a wrongful conviction, or would it be a wrongful acquittal?
Well, historically, an American system of justice really goes back even beyond that, but there's an old saying that it's better that 10 guilty people go free than one innocent person be convicted and go away to prison. And that's been a fundamental belief, I think, for a long, long time. I'm not so sure that it is quite the same nowadays. I think there are, frankly, some people who might think, well, you know, we got to crack down on this. Look at Guantanamo Bay, or look at, you know, somebody who's accused of terrorism. You know, would you rather 10 terrorists go free or one wrongly convicted person who wasn't involved in terrorism be imprisoned? And you know, a lot of it is people are scared. They're worried about their safety. Politicians take advantage of that. They they demagogue about it. They run on, let's get tough on crime. Let's lock them up, throw away the key mentality. And that is finally, I would say, in the last couple of years, starting to be challenged by people. And you know, for the first time in my life, I've heard both major parties, presidential debates, talk about criminal justice reform and, you know, the mass incarceration problem that we have in this country. In my state, Wisconsin, we now, in fact, for the last few years, we have surpassed the budget for Department of Corrections prisons is bigger than the entire University of Wisconsin system.
Wow.
Statewide, all the branches, all the different campuses.
As someone who's an alumnus from the University of Wisconsin, it's really difficult to hear that.
It's sad, but people are waking up and they're saying, wait a minute, this doesn't make sense. Why are we spending this much? I mean, way more than the rest of the world, particularly the English-speaking world, at least. You know, with our historical English common law, it has not been that way until recently. And it really, I think, started in the 80s with the cocaine and crack wars and the mandatory minimum prison sentences that have resulted. But people are starting to push back, and now I'm hopeful that there's some reform of that coming soon.
Yeah, it seems like the situation in the prisons in this country is starting to get attention finally. And what are your thoughts on the correctional facility, as some people like to call it? We've seen, as you said, explosion in the number of prisons. We've seen the privatization of prisons. How do you interact with that idea as an attorney? Well,
the first thing you do is try and convince the judge not to send your client to prison. And, you know, often we're successful. That's sometimes not. And what's really hard is when there's a statute that has a mandatory minimum, that if you're convicted, you will go to prison, and they're getting rid of parole by and large in most states, including Wisconsin. So, you know, if they say 5 years, it means 5 years. Or they say 25 years, it means 25 years. You don't get out after a third or a half. And that's also been part of the reason that the prison population has exploded like it has. But it's a very expensive way to punish people. And especially when you don't have rehabilitation going on at the same time, because the vast majority of people in prison will be released back into society at some point. And if they don't have a helping hand, there are programs now, one famous one is called Second Chance, that's very successful, and I'd like to see emulated more. But prisoners, you know, who get out back into society, particularly if they've been in, you know, 5-10 years or more, they need a helping hand. It's hard to get a job, it's hard to get a place to live. You know, even if they want to be law-abiding and try and reintegrate into society, it's tough. It's even worse for people, whether you go to prison or not, who are convicted of sex offenses these days. The sex offender registry has just exploded beyond anyone's original idea. The idea was that there's a few very really small slice of sex offenders who might be dangerous to others in the neighborhood, and that you should have the right to know if you've got a sex offender living in the block down or 2 blocks away if you've got your children running free. But what people don't realize is that 95% or more of sex offenses occur not from a stranger in the neighborhood or a stranger who abducts a child, particularly child sexual assaults. It's someone they know. 95%. It's stepfather or father, uncle or brother. It's somebody that being on our sex offender registry is not going to make you any safer. And then when they expanded it to include even teenagers who have consensual but still illegal sex, it's a sex offense. There's tens of thousands of people on sex offender registries in every state now.
And the impact of that, of not just jobs, but
they
apartments.
can't live. Yeah. There are places. This is really to show you how insane it's gotten. In Milwaukee, they passed, as a lot of places, they passed ordinances saying you cannot live if you're a registered sex offender within 1,000 feet or 2,000 feet of a school, park, playground, whatever. And it's gotten to the point where it covers the entire city now. And the Department of Corrections, when they supervise somebody, whether they're on probation or parole, they've got to place these people somewhere. And so what they've done is, it said you cannot reside. This was actually in the paper. What they've done is, the parole and probation agents tell the clients, don't reside, go stay with your mother or your sister or your brother for 3 or 4 days, and then go live in a parking lot for a couple of days, and then go back and kind of move around like a shell game because you're not actually residing anyplace. And now the Milwaukee's response is, well, we're going to change the ordinance to say you cannot stay overnight in any residence in the city of Milwaukee or within 1,000 feet of schools, which they overlap to the point where there's no place they can live. And therefore, you've got homeless people who are really no risk to reoffend, probably a bigger risk to reoffend the more ostracized and homeless they become than if they were treated more fairly to begin with. But that's just one example.
Right. Yeah. Yeah, that's tough. That's a tough reality to face. And speaking of the mandatory minimums, how does that impact a person's right to appeal? And how does that impact their appeal process? And how has the appeals process in the country changed over the last few decades?
Well, the mandatory minimums don't directly affect the appeal process any more than anything else does. But one thing that I think people don't understand about the appeal system, they think that if the jury gets it wrong, that it'll be fixed on appeal. You have a right to an appeal, and the Court of Appeals will correct the jury's mistake. And it doesn't work that way. The appellate system is much more focused on what's called finality of judgment, finalizing the conviction if there's a conviction in criminal cases, than it is in seeking justice. And so it becomes very difficult. 95% of appeals are not reversed. And there are many cases where the court will say, well, we might have ruled differently than this jury, and we don't think this evidence was that strong or that compelling, but we're not going to second guess them. And unless you can show that there are errors of law that the judge made, mistakes that they made in evidence allowing or not being allowed in, you're not going to have a chance on appeal. And even originally when DNA evidence came up, it was difficult initially to try and get a new trial, even when you could show that there was DNA evidence that was exonerating. I had a case I worked on for 15 years in Wisconsin on an innocence project before I could get this guy out. And all of those 15 years, he had at least one exoneration or exclusion of DNA evidence from the crime scene. And one wasn't enough. Suddenly it became, well, that wasn't important. Well, wait a minute. At the trial, you said this was critical evidence that linked the real killer to this crime scene. And now you're saying because the DNA evidence proves it's not this guy, that it's not relevant? And that's what they do. They're allowed to do that, unfortunately. And eventually the courts we had so much evidence that we were able to get him his case reopened and dismissed. But it's insane that it should take that long.
15 years to get there.
And he spent 29 in prison.
Wow. That is stunning. And speaking of that, speaking of wrongful convictions, the Innocence Project and the amazing work that the organization does and other attorneys do through the organization, why is it that the criminal justice system is not self-correcting? Why do we need outside third-party organizations to come in and do that kind of work?
Part of it is the lack of money. 80 to 85% of criminal defendants are too poor to afford their own lawyers, much less an investigator or an expert to talk about, EDTA or something like that, like you saw in the Making a Murderer. And despite the fact that we continue to prosecute primarily poor people, criminalizing poor people, we're not giving the funding to defend them. Anywhere from only a third to a half of the money that goes to prosecution ends up for the defense. So it's really obscenely low. Again, my own state, just to the north of you here, and it's not that much better anywhere. But Wisconsin now has, most states have a public defender staff that handle maybe 2/3 of the cases, but the remainder get appointed out to private lawyers on a list, and they're paid by the hour. Wisconsin is the lowest hourly rate in the country, worse than Mississippi, Arkansas, the Deep South that traditionally was bad. Even worse, what they do is they pay $40 an hour. When I first started practicing law in Wisconsin in 1981, they paid $45 an hour.
Wow.
1981. So, you see the quality of lawyers go down dramatically. The number of people willing to take on these appeals. It's very hard to get good quality defense attorneys. And there are, bad trial lawyers, there are bad appellate lawyers. And oftentimes what these innocence projects have had to do is kind of clean up the messes of either the courts or bad lawyering that's happened beforehand. And so, it shouldn't be that way. If we really care about the Constitution and we care about fairness, it shouldn't depend on whether or not you can afford your own lawyer as to whether or not you're going to get a fair trial.
Yeah, absolutely.
And that's unfortunately the reality is that people, it's hard. There doesn't seem to be a constituency for the legislators for somebody who's accused of a crime. Why should we give taxpayers money to defend somebody accused of a crime? Well, that's fine until it's your son or your husband or your neighbor, somebody who's been accused again that they never expected to be, and suddenly they're accused, and you're now thrown to the wolves with a really, really bad lawyer who, some of which you've seen depicted
on the documentary.
On the documentary, yeah. And unfortunately, that happens all the time.
I want to take a moment to say Jerry will take questions from the audience in just a few minutes. So if you would like to start lining up by the microphones. And while people are getting ready, I wanted to ask you. You mentioned this case that you worked on for 15 years, and we've all seen the Steven Avery case. I just want to hear from you. What is the personal emotional impact of working with someone who is accused, of seeing them very often, of interacting with their family, seeing what their family is going through, and also of what the victim's family is going through, right? Two families that have been put in a very difficult situation.
That's one of the reasons that Dean and I agreed to do this documentary, was that we wanted people to see what it was like to be a defense attorney preparing for a case, dealing with family. I didn't know that it was going to, what the filmmakers would put in and not put in. But one of the things that I think is really kind of unique about this the Making a Murderer documentary is you really see what it's like to be the defendant's mother. In this case, two mothers, going through a lot of turmoil and heartache. And poor Dolores Avery, who's, they show the map of all these prisons that she went to for 18 years, visiting Steven while he was wrongly incarcerated.
One of them in the South, right? Or just
One
quite
of
a
them
few
in the South because of
states away.
privatization.
Right.
At one point, they were using a Tennessee private prison to house people because they didn't have enough space in Wisconsin. The solution was to build more prisons in Wisconsin, which is ridiculous. The solution should have been not send as many people to prison or not as long. But this was back in the 80s and 90s. It's so that's one of the things I like about the documentary is that it does show that kind of interaction. It's interesting because in other parts of like the UK, for instance, they have two different kinds of lawyers, solicitors and barristers. And the barristers are the ones that go to court, but the solicitors are the ones that interact with the client and the family and all of that. And I've been written by a lot of solicitors who say, boy, that must be hard to be able to do that. Manage a family and all the things they're going through, and then also have to go to court. But that's just the way it is for us. And it's very, very hard when you lose. This case was a devastating loss for both Dean and I, and it was the hardest. I've said this before. It's the hardest one for me to disengage from. I had other cases that were sort of waiting while this case went on, and I needed to turn my attention to them. But it was difficult because I just kept, thinking about what could we do different? What could we have done different? What could we still do to try and right this wrong? Despite your best effort, you do get emotionally involved to some extent. You can't let it get, fall into despair when you lose, because when you're doing defense work, you do tend to lose. I mean, if the case is really that weak for the prosecution, they can dismiss it. What cases that go to trial are going to be a closer call generally, and but for me, it's always been kind of a vocation. I'm partly motivated by my faith. I believe that no matter whether somebody's really guilty of what they're accused of or not, there's dignity and worth in every human soul, and what they might have done on one particular day does not define them, in most instances. And when you go through the court system as a criminal defense attorney, you need to let the judge understand who that defendant is and why they are a human being, and they're entitled to be treated like a human being and punished if necessary, if it's appropriate, but not thrown out like garbage.
Right.
And so I don't know if that answers all of the questions you were getting at, but
It does. Yeah, thank you for sharing that. We appreciate it. And so with that, let's turn it over to the audience. We have some people at the microphones. If you'd like to go first.
Sure. I'm curious about, first of all, thank you for being here. But I'm curious about your thoughts on professional juries. Like, would that be a step in the right direction, in your opinion, to have people that are trained in that so that they understand what they should be looking at and what evidence, that's outside their purview that they should disregard? Because I always see that, like, it's crazy to me when you have like an objection and the judge just says, okay, disregard that happened. As if like a regular person off the street could just be like, oh, okay, that didn't happen. So I'm curious, like, do you think that would be a step in the right direction for us, something that we could do to improve the process?
That's been talked about quite a bit in the last 20, 30 years, maybe, particularly as science has entered more and more into the courtroom, and can jurors understand really the science and the technical stuff that they have to deal with? And like in patent law, for instance, it's all done by judges who are trained and really have expertise in that. But if you do that, you lose a couple things. You lose the idea of a jury of your peers. They're no longer your peers, they're professional jurors. And they're just as likely or just as great a potential that they will become jaded as some judges have. Whereas, I still prefer the concept of jury duty as it's a civic responsibility we all have. We should not duck it. You know, it's not the kiss of death when you get that summons. Oh my God, how do I get out of this? You know, it really is. You have a responsibility. You're defending the Constitution, acting as a juror, just like somebody who goes off to war. But you're not in danger of your life like they are. So people shouldn't run from it like they do. But along with that, you really need to have a judge willing to take the time to educate the juror, and lawyers willing to educate the jurors about their role, and so that they understand that if, you know, some cases they may not be right for. And it's okay to say that. You know, I might be a good juror in some cases, but not others. So that would be I think the focus should be more on how we make the volunteer jury, civic responsible jurors of our peers more educated. You know, it's interesting in this case, sometimes it's flip-flop. Sometimes the defense wants jurors of a certain type. Sometimes the prosecutor wants somebody just opposite. In this case, it was interesting that I think almost every juror that was questioned by the prosecution they started off with the question, are you a puzzle person? Do you like details, or are you more of a big picture guy? And if you were a puzzle person, you're gone. They struck anybody who had any interest in like looking at the real details, because that wasn't going to help their case. So we, on the other hand, didn't have that luxury. We had to get rid of people who were so biased already that it was obvious. And you get a certain number of peremptory strikes where you can get rid of jurors for various reasons. And we had to use all of ours on ones that, frankly, should have been struck by the judge. So anyway, it's a long answer for your question. Sorry about that.
Thank you.
Was there anything that the documentary that you felt left out or may have biased in a different way? I think that it seemed like if you were in the town at the time, they were biased in one way, and I think if you watch a documentary, you might have been slanted in the other direction just naturally by the way of the film was brought. So was there anything you felt that it didn't look at objectively in the film, or that should have been left out or should have been added?
Well, they had, the filmmakers, complete editorial control over what was included and what wasn't. And I'm not going to criticize them for, any filmmaker's got to make choices. This was a 6-week-long trial. They had 10 hours for the whole documentary, and maybe 3 or 4 of it was the trial, this particular trial. So, yes, there was a lot that was not included, but from both sides. But I will say this, when it comes to the evidence, in the trial itself, I thought it was very fair and balanced. There was definitely more of a defense perspective because of our willingness to participate and the prosecution's decision not to. So you got to see us kind of talking behind the scenes and what are we worried about and brainstorming how are we going to deal this and that. You got more of the defense perspective. But when it comes to the evidence that the jury heard, that was really balanced and fair. There was other things that weren't included that would have been, we thought were more important for the defense, and that the special prosecutor immediately started crying foul. You didn't include this, that, or the other thing. And he had this whole laundry list of things that were left out. But what he ignored is that if you go back and, I say this, the easiest way to tell what's really important to a lawyer is to figure out how much time they spend in their closing argument on it. And you've heard about the hood latch DNA that was not in the documentary that supposedly was this very compelling prosecution evidence. The prosecutor spent 15 lines of his closing argument, a half a page, out of hundreds of pages, hours long this stuff. And the reason is because it was fully explained by the state's own witnesses at trial. And it became neutralized, and it was no longer a big issue of contention because their own experts admitted they were inside the vehicle sampling, had gloves on, went out, wanted to check the odometer, the battery wasn't connected, lifts up the hood with the same gloves. And the amount of DNA that was found on the hood latch was very small, consistent with that kind of innocent transfer. Like if I shake your hand and you go off and rob a bank and my DNA might be on the gun, I never touched it, that kind of thing. So there were those sorts of things that but when it came down to the real evidence that was fought over, the blood in the RAV4, the magic key and the bullet and the bones, those things were really as balanced as I think they could be.
Now, Jerry, we are at time, but do you mind sticking around for one more question?
Sure, I'd be happy to. I mean, you can't do it in 2 or 3 minutes on the TV news. I know they need a conversation.
Thank you. So we can go over here.
Thank you for being here. If I remember correctly, one of the things in the beginning of the trial they talked about was you were not allowed to, as a defense team, to start saying other people could have done it, right?
Right.
And I'm a law novice, I suppose, but can you talk a little bit about that? Is that a typical thing? Is that something you deal with like in every single case, or what is the thinking behind that to
Sure.
the overall process?
Sure. Most states have a similar kind of rule, which basically is that they don't want the jury to become distracted about what's the real issue. Putting somebody on trial who's not there to defend themselves by pointing the finger at a third party and saying he did it or she did it, you know. And so there's always, most states have some kind of controls or limits on what you have to show in order to be able to present that kind of evidence. But typically, and in Wisconsin until this case, you had to show that somebody had access, opportunity to have committed the crime, what they call a legitimate tendency towards that. But you did not have to also have motive. And in this case, the judge made a ruling beforehand that we had all these people that could have been the killer. They had just as much access and opportunity as him, but because we couldn't prove that they had a motive to kill her, we weren't allowed to point the finger at that person. And we said, wait a minute, the state does not have to prove that Steven Avery had a motive to kill. The prosecution almost never does. All over the country, they have to prove, like in a homicide, they have to prove intent to kill, but not why, which is the motive. And so, how unfair is that? They're the ones that have the entire burden of proof in the case. We have no burden in the case, and you're telling us we can't even let the jury know that there's other suspects out there because we can't prove that they had a motive. And then what you end up with is the accident, so to speak, of if you happen to be unlucky enough to be accused of a homicide of somebody who doesn't have a lot of enemies, who otherwise wouldn't have a lot of people that would have a motive to kill them, like Teresa Halbach here. As far as we knew, there wasn't anybody who had a motive. Part of that, though, is the law enforcement never really investigated her background. I mean, her circle of friends and acquaintances and people in her life. Remarkably little investigation in this case. But versus somebody who's, a drug dealer who's been ripping people off and maybe has a lot of enemies, which would be easier to prove. If you happen to be accused of one where there's not an obvious motive, then you're screwed. He layered that on in Wisconsin in our case as an additional requirement in order for us to do that, and said we weren't allowed to use it. When the case was affirmed on appeal, that became the law in Wisconsin, and now we have one of the toughest in the state, in the country, to be able to introduce that kind of evidence.
Thanks.
Sure.
Hi, I've got a two-part question, if you
All
don't
right.
mind. So firstly, I'm thinking about the courtroom and wondering if you think that the setting of the courtroom is really an optimal way to align your evidence so that the jury and the decision makers can make a decision. Perhaps there are a lot of factors like timing and just randomness that can really make or break the case for your client. And if you don't think that it's perhaps the optimal way to go about bringing justice, do you think that there could be an improved way to really make that happen?
Well, in America, we have what's called an adversary system of justice. The idea being that a trial is a search for the truth, but sometimes that's elusive, particularly when credibility of witnesses, who do you believe? He says one thing, she says another, somebody else says the third thing. If it's a bar fight where people are intoxicated and you have lots of stuff going on, you may get a different perspective from everybody who was there. The idea, though, with the adversary system is that witnesses come into court, both sides can question the witness and try and bring out facts or, like whether they were impaired and maybe you didn't see this that clearly, and if the two sides are relatively equal, that the truth will be in there somewhere and the jury will be able to then discern the truth. Unfortunately, the two sides aren't always equal, particularly nowadays where the defense is so underfunded, particularly indigent defense. But there are other problems. It's not ideal for jurors to try and think about something that happened very quickly that's being exploded into a little, microseconds of this, that, and everything happening. But short of that, I'm not sure how else you do it. I mean, there is an opportunity, for instance, for jury visits to the scene of a crime, where they can maybe get a better perspective on what the witnesses are talking about. You can't really do reenactments of what happened. That, you see that on TV and cable sometimes, with scary music going on. But, so I don't, I still think it's the best system that you can come up with, but it's not like it doesn't have its flaws. And we see a lot of them in this documentary. It's law enforcement. It's very difficult if you've got a case where you think someone is being framed by law enforcement. Very difficult to defend against that, because who knows better than police how to frame somebody? Think about it. What would you do? How easy would it be if you really wanted to do that? There's not a real good solution to that, other than you need to make sure you try and hold your law enforcement accountable just like anybody else. And if you've got bad cops, they shouldn't be rewarded by taking over the department, moving up and now being the head of evidence. But that would be I still think it's the best way to do it is in the courtroom with the adversaries on both sides, but it definitely, you have to watch for the flaws and remedy those where you see them. Okay.
Thank you.
Sure.
Hi, thanks for coming. It sounds like the prosecution is often motivated to convict someone as opposed to the right one. So is there anything to be done about this problem, or is this a symptom of something else being wrong?
Well, there is, it's interesting that, all lawyers are bound by a certain code of ethics. Prosecutors, though, have their own. And it's interesting because they should, because one of the things that they're supposed to do ethically is seek justice, not a conviction. But that's oftentimes difficult because human beings, you get into the battle you want to win. And sometimes they can lose sight of that and lose sight of justice. But I think most prosecutors try not to do that, but it's sometimes hard to. For instance, the case I mentioned where I worked for 15 years, that same prosecutor was on the case from 29 years ago all the way to the end, almost to the very end, finally retired. But he was not a guy that was generally considered to be a jerk, biased, corrupt prosecutor at all. But I think it was difficult, and you see this time and time again on DNA exoneration cases. Prosecutors do get emotionally involved with victims and their families. And the idea that not only did they convict the wrong guy and send the wrong guy to prison, but that the killer or the rapist went scot-free. It's hard for them to look into the victim's family's eyes and say, I'm sorry, we let this guy go, we screwed up. And so humanly, it's difficult for them to step back and be objective. One way to maybe improve the chance of something like that, at least with post-conviction, is to try and make sure there's a different prosecutor taking over the case and examining it with a little more objectivity.
Thank you.
All right.
Sure.
Thank you. Jerry, thank you so much for
You're
coming.
welcome.
We really appreciated hearing from you.
Okay.
Good luck on your tour.
Thank you.
Conversationonjustice.com. And
And I'm writing a book.
all right.
And it's not just about the Steven Avery case. In fact, the case I mentioned it will be talked about in a lot more detail. And I tell people that as bizarre as the Steven Avery case is, you would think that's the craziest one I've had. It's not. I've had crazier ones, just as interesting. And yeah, I've been really blessed with that in my career. And so, as a criminal defense attorney, that's what you want. You want some challenges.
We're all very much looking forward to the book.
Good.
All
All right. Thank you.